All right, well, we can go ahead. We're all set.
Sure. So Ellen Tchaikovsky, I'm here from the Office of Legislative Counsel. So I'm the attorney from Leg Counsel that handles land use, energy, and climate change. And I do overlap on natural resources stuff with Mike O'Grady a little bit, but I handle land use, which includes municipal zoning as well as Act 250. So I'm here today to give you all an overview of a brief introduction to Act 250. I think that will do my, and I'm also going to talk then about Act 181 last year that made a ton of changes to Act 250. So I am thinking this will be a bit of a conversation if you have questions, but this is the high level introduction of what Act 250 is. So Act 250 is a statute codified in Title 10, Chapter 151. It's actually the full name of Act 250 is the State Land Use and Development Law. So Act 250 is about permitting large development in the state. So the operative language of Act 250 is this sentence that's there at the top, which is captured in Section 6081A, which says, no person shall sell a subdivision, commence development, or commence construction of development or subdivisions without an Act 250 permit. So there's two words in that sentence that you really need to know what they are in order to know if you need a permit, and that is subdivision and development. So those two things have very specific definitions in Chapter 151, and there's quite a few things that fit under those definitions. What we talk about mostly in bills usually is development. What is development? What is it that I need to do that triggers my need to get a permit? And so development has these 9 or 10 definitions. The one that I talk about most in my work are the ones that are highlighted. So development includes all these things, but specifically the second one, the construction of improvements for any commercial or industrial purpose on more than 10 acres of land or on more than 1 acre of land if the municipality does not have both permanent zoning and subdivision bylaws. It also means the construction of 10 or more housing units, or the construction or maintenance of mobile homes or mobile home parks with 10 or more units within a radius of 5 miles. So primarily, Act 250 applies to commercial construction if it's located on more than 10 acres land or more than 1 acre of land, or for housing developments, including 10 or more units. So it does not apply to a person constructing their own home, generally, unless there's something else going on that may trigger Act 250. And then there's other ways that you can get into Act 250. There's also a specific definition for the government. So if it's a municipal, county, state, or public project, that can trigger Act 250 as well. And then the last one I just want to mention quickly is that Act 181 of last year, the big housing/land use bill that was passed, added a new definition of development, which is the construction of a private road longer than 800 feet or a combination of private roads longer than 2,000 feet. And that doesn't kick in until 2026, but that is new as of last year's bill. But in addition to all of these definitions of development, there are 2 lists of exemptions within Act 250. There's one in Section 6001 and one in 6081 also. So while it does broadly apply to commercial development, there is also a long list of things that are also exempt from Act 250. There's also a definition of subdivision, which is specific. And so this is when a tract or tract of land owned or controlled by a person, and that person has partitioned or divided for the purpose of resale into 10 or more lots. If it's in a town with zoning. If it's in a town without zoning, it's if they divide into 6 or more lots. And then if for some reason they're offering them for public auction, there's a definition that says if 5 or more lots, if they're offering it for public auction. So this is setting up this dichotomy, which I'll talk about again in a moment, where depending on if the town has zoning or not, the size of the threshold is different. So a person dividing their land for the purpose of resale into 10 or more lots or 6 or more lots will trigger Act 250 need for a permit. So here is, do you need an Act 250 permit? A brief and incomplete analysis for illustrative purposes. So what are you doing? What is the purpose of the development? You're constructing something. Is it for a commercial purpose? So that's pretty much anything that isn't a governmental purpose. So is it for commercial or industrial, or is it for a governmental purpose? So municipal, county, state, public purpose. If it's for a commercial purpose, does the town in which it is located have have permanent zoning or subdivision bylaws? Under Act 250, we call this a 10-acre town or a 1-acre town. If it has zoning, it's a 10-acre town, and if it doesn't have zoning, it's a 1-acre town. So if it's a commercial project in a 1-acre town, is more than 1 acre of land involved? If it's in a 10-acre town, is more than 10 acres involved? For a commercial project, involved means the whole tract of land. So are you going to construct a commercial development on a tract of land that is larger than 10 acres? Or if you're located in a town without zoning, more than 1 acre? So that's the set. If it's for a government purpose, involved means the area of disturbance. So it's actually a higher threshold for government projects. But for an individual person, a commercial project, you're looking at the acreage of land on which you're going to construct something. So then if you meet that requirement, the applicant must demonstrate that the project will comply with the 10 criteria of Act 250. So there are 10 criteria, but we all know that there are more than 10 criteria. Here is the list. Criterion 1 is about whether or not the project is going to cause undue water or air pollution. And there are a bunch of types of issues under that that require you to look at different aspects of your project. So are you in the headwaters? Are you looking on a stream or within a shoreline, or are there wetlands? Criterion 2 is about ask if you have planned for sufficient water for your development. Criterion 3, are you going to then provide an undue burden on the existing water supply? So did you check you have sufficient water? And also, did you check with the water supply that is actually going to be sufficient? Is it going to burden the water supply, or are you going to take too much? 4 is about, are you creating unreasonable soil erosion? 5, unreasonable congestion or unsafe traffic conditions. So a lot of people do describe these criteria as environmental criteria, but roughly half of them are actually about community impacts. And so are you going to have unsafe traffic conditions caused by your project? Have you done traffic study? Are you going to need a turn signal? 6 is about, are you going to cause an unreasonable burden on educational facilities? Are you trying to build a 10,000 unit home development in a town of 600 people? That might be difficult for your schools. Same with criterion 7. If you are bringing in a huge influx of people, are you going to cause a strain on the governmental services like fire and EMT in that community? Criterion 8 is about aesthetics. There's a lot of things that fall under this category, but the scenic natural beauty of the area, historic sites, natural sites, rare and irreplaceable natural areas, as well as wildlife habitat and endangered species. And then last year's bill also added this new criterion. Are you going to have an undue adverse effect on forest blocks and connecting habitats? 9 is a big catch-all category that is about planning and development. It asks if you're going to have an impact on growth. Is there going to be an impact of growth from your project? Are you also going to have a negative impact on the primary agricultural soils on the land you're going to build, or the productive forest soils where you're going to build? Are you going to have impacts on the earth resources, which are like the mineral? Are you going to are you going to damage them? Are you going to cause any inability to have extraction of the earth resources? Are you practicing energy conservation on your project? Will you be negatively impacting the utility services there? Are you going to cause sprawl, and what about the public utility services? So there's a lot of things happening in criterion 9. And then finally, criterion 10 asks if you're conforming to the local and regional plan. So have you conformed with the municipal bylaws? Have you conformed with the regional plan?
I saw at least one hand. Is it okay to interrupt?
Sure, yeah.
Representative O'Brien?
I just wondered, can you trigger an Act 250 permitting process if you just have it, nothing changes, but you just change the usage of what's there? Say a residence becomes a commercial business. Nothing, no ground is broken.
Well, so how did a personal residence become a commercial? So the trigger in Act 250 is the construction of improvements. And so that is any physical change to the project. And so I think it would be hard for as with everything in Act 250, the details of the specific project are important to know. So if it's not located on more than 10 acres, probably not. If it is, I have to assume that going from a single family home to a business would require some change.
Okay, I was trying to think of examples, like say I have a goat dairy, but now I'm getting rid of that and I'm gonna just have goat yoga. I'm not a farm anymore. It's a recreational business.
So you were exempt because you were a farm?
You're exempt from,
Okay.
okay.
Just raising goats for yoga, maybe that counts.
Maybe,
You're
it's not.
You're breeding them.
Well, right.
Yeah,
Agritourism.
It is agriculture.
well, did you
We
put it,
don't pay to come see that.
did you put in a parking lot? to-
Right, well, that's what I'm wondering, right, or,
So I think that is one of the gray areas where that lead people to questions or lead people to say, well, I don't think I need a permit because I didn't construct anything. It is better to check proactively to see if it's difficult to speculate because it really does depend.
and what power do abutting landowners have to challenge, to say, oh, goat yoga's clearly not a farm, they shouldn't be exempt anymore.
So yes, so part of Act 250 is complaint driven. And so anyone can request a jurisdictional opinion of any project at any time. And so they can proactively seek an opinion from the land use review board on whether or not something that's going on does have an Act 250 permit or needs an Act 250 permit. Additionally, anyone has the ability to file a complaint with the land use review board to say, I think someone is currently not complying with their permit. It used to be one thing and now it's something else. Wasn't their permit for something else? So yes, people at any time can raise concerns. They do have an enforcement division that has a few officers that do go out and do site inspections and contact landowners. So that is part of the work that the board does.
Representative Nelson?
So, thank you. If John's goat dairy was located in East Overshoe and they had stringent zoning regulations and he wanted to change to goat yoga, and if the zoning board went through everything, which answers neighbors' issues, would he be exempt for Act 250 then because local zoning and permitting is taking care of it?
No.
So you supersede town plans and local zoning?
No. So the municipal zoning system runs concurrent to the Act 250 process. They overlay at some points, but if an Act 250 permit is required, you may also need a municipal zoning permit. If a municipal zoning permit is required, you may or may not need an Act 250 permit. While those two things happen at the same time, it depends really on what is happening in the situation. About half the towns do not have zoning. And in those situations, an Act 250 permit may or may not be needed. Act 250 primarily covers large projects. And so things that may not trigger Act 250, like a single residence or a smaller entity, may trigger the local zoning. And in places where there's no zoning, neither may be needed.
And Representative Lipsky?
Alan, thank you. you go back to the first highlighted, that one.
Yep.
Down near the bottom, construction of private road longer than 800 feet or combination of roads longer than 2,000, not until 2026. Take a farm road that may go 2,000 feet just to get to a back pasture or field crops. Is that considered a private road?
So I was doing the high level. So last year, this policy was discussed and it has been for a few years. There are a lot of details to the road provision. Farming and forestry logging roads are exempt. Unless they get converted to roads used for private residential use. So roads that are used that are constructed after 2026. So it is prospective. Roads that are constructed after 2026 that are used exclusively for farm purposes will not be captured by this.
Right.
And it does get complicated from there. There is a rule-making provision that does ask the board to provide additional details because there is the sort of line about at what point does someone adding a house to that farming road become a commercial development? And so there are some things that need to be worked out, but the details of this are in Act 181, but are also now in the statute. And I can, it's in section 19 of Act 181, if anyone wants to look at it specifically.
Representative Morgan,
Or can I just follow up on?
please.
This provision, I, for one, felt it was punitive to rural families that might have a farm, whether it's 80 acres or 8,000 acres. They had someone in the family that wanted to stay with the farm and build 800 feet. Maybe it would be a farm road that would be converted when they become of age. That was punitive to rural Vermont. And I did not support this bill for that reason. So that for rural Vermont, that's increased the liability of being drawn into Act 250 as opposed to was helpful to rural Vermont families. That maybe I don't know if that was intent, but that was the result. It's resulted in that increased liability.
All right, Representative Morgan.
A private road is not the same as a private drive, correct? Because in the past, in our dealings and other
Yes,
committees
yes,
with
we
this,
did have a log just, so.
and a private drive was, you could always go up to 800 and no further, correct?
And so this is one of the interesting distinctions under this definition that does make it tricky, which is there's a distinction between what is a driveway and what is a road. In the past, there's been court decisions that say a driveway is something that serves one home. A road is something that serves more than one home or other things. The definition that was included is that it is a single road or the length of all roads and associated driveways in combination would be 2,000 feet. So it does attempt to get at this distinction. I do think there may need to be additional clarity added when the board does its rulemaking.
All right, and as you note in the bullet at the bottom of the slide, there are lots of exceptions or exemptions, lots of weeds, lots of rabbit holes, other things that could take up the next half hour, but why don't we take a look at the last slide? You had one more.
Oh, and so, yes. So what the basic process for the Act 250 permit is that once you have determined that you do need a permit, you submit your application to one of the 9 district offices. Those district offices are not the board. They are located within, they are roughly by county, and so some of them have 2 counties in them, some of them only have 1 county. But those districts are staffed by a district coordinator and sometimes additional like assistants, clerk staffs. But the applications are reviewed by 3 members of the district commission who are essentially volunteers that are appointed by the governor. They receive the $50 per diem payment for when they hold hearings on these permits, but they are not state employees. There's also some alternates that are appointed, but this is people who live in the county, in the district where they are overseeing the permits. And so those people review the permit. They then determine if it requires a hearing. If it doesn't, it's considered a minor application and will receive its permit within 20 days. There's a set timeline for minor permits to be issued. It could also be an administrative amendment, which is just an update to an existing project. The vast majority of permit applications fall into those. I think it's more than 80% are either a minor application or an administrative permit. If it does need a hearing because the district determines that there's going to be some kind of controversy or there's an issue that they perceive, there's something complicated about it, they will hold a hearing. Those hearings are open to the public. Members of the public may participate, but the only people who are allowed to join as parties to the case are those that have a particularized interest. So they have to demonstrate that they will be personally impacted by the project in some way and they want to join as a party. They then are required to participate throughout the hearing to maintain that party status, and they can be removed at any time if they're not participating. So it's a higher standard that we have for other types of processes where it does require engagement from the beginning of an application in order for someone to participate. The district commission then has the option to approve the application, deny, or in most cases, approve with conditions. Those conditions are allowed to be attached to mitigate an issue under one of the criteria in order for them to move forward with the permit. So the goal is to find a compromise so that they can make some sort of tweak to it to avoid an impact under one of those 10 criteria that I mentioned. The only people that may appeal the decision of the district commission are parties who have participated. So either the person seeking the permit or someone who has maintained their party status. If they're going to appeal, they will appeal to the environmental division of the Superior Court. And from them, they have the option to go to the Supreme Court with further appeal. So that is the basic process of Act 250.
Question, John?
Just quickly on, so are there cases where like a development or subdivision will pass its Act 250 hurdle, but a DRB may turn them down or vice versa?
Yes.
And do any towns with the DRB or municipal zoning, do they just accept an Act 250 permit as enough to continue on? Like, is that the gold standard essentially?
No. So zoning looks at different things than Act 250 does. Zoning is more about what the project is. And they may also look at impacts, but towns usually are formulating their zoning about what are the types of uses we want and where are they. Whereas Act 250 is looking at how large is your project and what are the types of environmental and community impacts that you're going to have. And so they aren't necessarily apples to apples. Some of the larger towns have adopted more of the Act 250 elements into their zoning. And so that is what sort of led to Act 181, which is there are towns that are doing very detailed review of projects that may cause there to be duplicated effort that could be reduced by this new tier system that I'll talk about. And so I don't think there's anyone who just says if you have an Act 250 permit, you can have a zoning permit, because really they're looking about, are you in the right location that the town has decided this project is good for? And have you abided by, there's a lot more like building type standards in zoning, like the setbacks, the coverage of the lot, that Act 250 is not looking at.
Distances between septic and water, distances from a river, differences from distances from deep slopes. That's what a lot of our zoning is concerned about. And whether or not it's in that particular, it fits in that particular zoning district.
Yeah.
As opposed to what Act.
So I think Ellen now is going to talk a little bit about some of the changes, maybe all the changes that Act 181 made. And I think it would be helpful, since we're thinking about this in the context of a particular proposed change to the current use penalty that would favor affordable housing. So the changes that the legislature made last year in 181 that are housing related, or where the intent was or seemed to be to encourage housing, I think those would be good ones to focus on.
So I also provided today, it's posted on your website, the summary document for Act 181. Act 181 is 171 pages. So it's been easier for me to this is what I actually provided the legislature at the end of the session last year, but this is the same document. So it has the quick bullet points with each of the sections. And so I'm going to be working off of this, and then I also have the specific text if we need it. But the first handful of sections of Act 181, changed how the Act 250 board works. And so it made it a full-time professional board, gave them different additional staff, slightly changed how they're appointed. And so there is a new governing structure at the agency that administers Act 250.
We heard from the new director of the Land Use Review Board a couple weeks ago. Yeah.
Yeah, we changed the name from the Natural Resources Board to the Land Use Review Board. And so, yes, they're now the LURB. So the next sort of set of changes, I already mentioned there's a new criterion under Act 250. It's about forest blocks and connecting habitats. That's in sections 12 through 15. Then section 16, this committee had looked at, this is a change for wood products manufacturers. So this adds language regarding lowering the amount of required mitigation for wood products manufacturers if they're going to impact primary agricultural soils. So it lowers the payment ratio from between 2-to-1 and 3-to-1 to 1-to-1. Additionally, this committee also worked on sections 17 and 18 of Act 181, and that's the accessory on-farm business provisions. Section 17 updated the definition of accessory on-farm business and broadened what it can include. It also, in section 18, created a new partial exemption from Act 250 for accessory on-farm businesses. Section 19 and 20 are the provisions related to the construction of private roads, which we were already talking about. And then starting with section 21, there's a series of sections that are seeking to change the way Act 250 decisions, how the structure of Act 250 is laid out. So for the last 54 years, Act 250 has used those definitions of development to determine if you need a permit. Starting with section 21 and thereafter, we're setting up a tiered-based system, which is going to be used to determine if you need a permit based on the location of the project. So we're setting up the tiers. Tier 1 are areas where it's been determined that little or no Act 250 jurisdiction is needed. Tier 3 is the opposite. Those are sensitive, critical natural resource areas that need more Act 250 oversight. And Tier 2 is the middle and is currently just the status quo of how Act 250 has been operated. But the Tier 1 areas are the areas where the municipalities have gone through a process to determine that this is where they would like to see exemptions from Act 250. The theory being that they are doing the review of the impacts of the projects through their municipal zoning process. So Act 250 oversight is not needed. So I'll talk about Tier 1 in a minute. Tier 3 is going through a rulemaking process at the board, and so the details of it are a little bit scant, but in those areas where tier 3 is determined to be, these are critical natural resources. There's a list of examples of what the legislature thought would be tier 3, like within wetlands and a buffer around wetlands, within floodplains. Those are areas where jurisdiction will not be based on the size of the parcel, but the project itself. The opposite of that is the tier 1. So tier 1 of this new system, there are two parts of it. There's tier 1A and there's tier 1B. Tier 1B is a partial exemption for Act 250. It is an exemption for a project up to 50 units of housing from Act 250 if it's located within tier 1B. These areas are determined by the municipality in conjunction with the Regional Planning Commission. The Regional Planning Commission they are all producing new regional plans and regional maps to conform to Act 181. But in conversation between the town and the Regional Planning Commission, they will determine what areas of the town are suitable for tier 1B exemptions. Tier 1B does require the town they have to opt into this. They want the towns to affirmatively identify that, yes, these are the areas we want to be considered tier 1B, where there will be an exemption from Act 250 for this housing. Tier 1A is a full exemption from Act 250 for the region, for the area of a municipality that has been designated as tier 1A. A town will have to apply to the board to have this area designated, to have the boundaries of this area identified and mapped. And then all development within the tier 1A area is exempt from Act 250, not just housing. Until then, there is a set of exemptions from Act 250 for the next 3 years for housing development until these tiered areas are mapped. So there's a deadline of the end of 2026 for the regional planning commissions to update their regional plans and maps to reflect the boundaries of these areas. That's considered the first step. So it does require the municipalities who make up a regional planning commission to work with their regional planning commission, figure out the areas they want to be included in these tiers, and then have those maps and plans, the regional plans, submitted to the Land Use Review Board for review and approval. So currently, all of the regional planning commissions do have maps and plans that have existed for some time, and they have a regular schedule by which they update them. But no one oversees them. No one necessarily double checks their work. So this is adding a level of review to make sure that in addition to the tiered part of this system, all the other elements of a regional plan are included in the document.
Representative O'Brien.
So if you're a 1 acre no zoning town, you're not even really eligible to do tier 1A or B.
Correct. The first question for tier 1A or B is, does the municipality have permanent zoning?
Okay.
Yep.
So just because the question has come up in my mind anyway, because something I saw or something I heard, if you don't have zoning and subdivision laws, but you do have infrastructure, that doesn't qualify you for
Correct.
Tier 1A or either tier.
Either.
Okay. So you need zoning.
Yeah. So the thinking behind this was, there have been claims in the past that Act 250 is duplicative of what's already happening at the town. And Act 250 does predate much of our municipal zoning. And so this is saying, all right, it's been 54 years. Are there towns that are same level of review of projects that Act 250 has always used? And so the first question in both tiers is if they have zoning. So for tier 1B, the municipality has to have, they have to have a town plan, which is the first step before you have zoning. So town plan and then permanently adopted zoning and subdivision bylaws. They have to exclude from the area they want as tier 1B, the flood hazard and fluvial erosion areas, unless they have adopted the flood hazard area and river corridor bylaws, which do require flood proofing. They do also have to have the infrastructure. So they have to have either water supply, wastewater infrastructure, or soils that can accommodate community systems. And they have to have staff, municipal officials, or contracted capacity adequate to support a development review process. And so they have to have a zoning process up and running with staff to handle applications. So the point is that the town itself, even though Act 250, there's exemption, that process is not going to happen. The municipality has to be doing their zoning review and issuing permits.
So in the future, can towns be challenged on some of those criteria in Act 250, even though they're exempt, like, oh, this 100 family development is gonna overtax our, government services or schools, like in Act 250, or?
So for tier 1B, it's probably not. Because that is not specifically required. I do hope that towns are looking at that and their own needs as they do this review. That is not specifically required, particularly for 1B. And I actually don't think it's called out at all in 1A either, because really we hope that towns are doing that, right? Like that's their educational system and their fire and safety. So hopefully they know what would be adequate. Act 250 has functioned previously in a way to say, for better or worse, you are going to burden the town. Is there a way for you to compensate the town to help them expand their services to address what your project is bringing in? Hopefully the towns themselves, when they're doing this review, are thinking about that.
So, but
They would have to have that in their zoning, and
as
I
far as
don't think it's specifically called out that one, but yeah.
complaint-driven things are no longer eligible, right? If you're in, say, tier 1A, right?
So the other part of this is that the municipality is required to take over an existing Act 250 permit if it's located in the exempt area. So yes, they are to be enforcing the conditions that were in the Act 250 permit unless they're no longer related to what's happening at that site. Yes, and so it really is about the town stepping in the shoes of what Act 250 was doing for those sites.
Do we have any sense, I know the maps are still being drawn, but any indication of, how big in total the tier 1s are going to be, 1As and 1Bs?
Yes and no. So tier 1As are to roughly correlate with what we had as designated downtowns and village centers. And so that is, I didn't talk, there is more detail about the regional planners looking at what are the core areas of municipalities, which do roughly correlate with areas that had been previously designated under the designation program. And so not all towns had them then, as the program has existed. 23 towns had designated downtowns. So we do know the existing acreage of towns that had already gone through the designated downtown process. And so those are pretty compact areas really around the downtown core. And I think in large part, this is trying to also reflect that. And so it probably won't be whole towns that will be in the tier 1 area. Tier 1 areas, they will be portions of the town where they have the infrastructure and the bylaws that apply to them. So I do think that I don't have an actual answer to your question, but the regional planners do have a lovely presentation with maps that they've been bringing around to the buildings if you'd like to see them.
Okay, good. Well,
Yeah.
we will invite the regional planners to come in and share that. And I'll get to your question in a second, Richard, but is there, I think what we're, sort of wondering is whether there's going to be land that's currently enrolled in current use in tier 1B, probably not in tier 1A. But I don't expect you to have that answer off the top of your head, but
It strikes me as not common. Although I don't know a ton about the different types of current use categories. But at least in tier 1A was intended to be more of the cores. Tier 1B is a little bit farther than the actual downtown of a municipality. And so it's hard to say because tier 3, which we don't yet have a ton of information on, is things that would be the habitats and sensitive natural resource areas, like highest priority forest blocks. And so depending on if it was located in a tier 3 area with sensitive natural resources, it would not be in a tier 1B area. And so potentially I don't know if I can be more specific than that, but
Representative Nelson.
Thank you. You mentioned earlier, probably 40 minutes ago or 30 minutes ago, about prime ag lands.
Mhm.
If development is gonna take place outside of city centers, municipality centers, a lot of this land is in current use right up to the edge of the village. It is up where I'm from, up in Derby, in Irisburg, and in Coventry, and a lot of places up in the northeast. And those are all prime ag lands. They're also the lands that are most forgiven for development because they don't have wetlands on them. They don't have steep slopes. They don't have. And I cherish all our prime ag lands, but I also realize that we have stifled growth in these communities and really made a mess of our demographics and our ability to survive through healthcare and education. What are the penalties for taking land out of prime ag to allow this responsible, keyword responsible to, I'm not talking about someone building a McMansion, although I'd love goat yoga, but for workforce type housing.
So Act 250 permits are one of, I think, the only mechanisms that do require protection of primary agricultural soils. And so currently under Act 250, if you need an Act 250 permit because you're going to construct something and there's prime ag soils located on the site, you are required to mitigate the damage to them. You're either required to reconfigure your construction to impact the least amount of soil as possible, or you're allowed to pay a fee to purchase prime ag land elsewhere. And that is the ratio I was mentioning earlier. There's a formula. And so the formula in statute currently requires that if you're going to destroy primary agricultural soils because of your construction, you're required to conserve more than what you destroyed elsewhere, so that it's not a full net loss. But I don't think there are other programs that do that. And so if someone constructs something and doesn't need an Act 250 permit, they won't have to do any prime ag soil mitigation.
Now, there's a block of land up on that's done nothing for years. And it's beside the golf course, the 191 access road down into Newport. It's in the town of Derby, but it's adjacent to development and all the services. And it's designated prime ag land. And it's really a spot, we don't own it, we don't own. it. But it's really a spot for high density housing. And the reason it hasn't gone forward is because of this penalty. And the undue burden it's gonna put on affordable workforce housing. So you talked an 8-to-1,
It's 2 to 1 to 3 to 1.
2-to-1, 3-to-1.
Yeah.
So are you basing that on its ag land value at, not even the current use rate, $5,000 an acre? Are you basing it on $5,000 and then they gotta pay 3-to-1, so they gotta pay $15,000?
I am looking at the statute and there is a formula in the statute. It is based on the level of prime. So there are 10 categories of the primary agricultural soils. And then it is also based on the average parcel price per county. So this is a formula that the Agency of Agriculture developed. So that it is in, the formula is in statute, the individual data is monitored by the Agency of Agriculture. Yes,
Price of ag land.
the price of ag land, yes.
So the 3-to-1 though, would it be
But yes, it is roughly what you're saying, yes,
3 times the price of the ag land?
yes.
And that's, so, and mitigation is you pay into a,
For
into the
Vermont
conservation.
Housing Conservation Board, probably.
Yes.
So you can understand why no one can afford to build a home in rural Vermont, even though they're surrounded by development or in a community.
Representative O'Brien?
Ellen, can you, like, if you're a municipality, can you aspire to tier 1A or 1B, even though the land's not ready, or does it really have to be shovel ready? Like Richard was just mentioning, that land has municipal, say, water and sewer already to it.
So there's sort of two parts there. The municipality has to be ready. It's not about necessarily the land. So there's the municipality has to have their zoning and their staff in place, and they do have to have the infrastructure to get this designation.
They can't, say in the next 20 years, this cornfield is gonna have municipal sewer and water, and we're gonna develop it, and we're zoning it as tier
No.
1B.
No, but the municipality can ask at any time, and I think we do anticipate that over time towns will say, oh, I do want to add the additional zoning requirements that would get me to then have an exemption there. So it's essentially rolling, and they will have the ability to add additional non-contiguous areas for these tier 1A and B areas.
The, nothing in the legislation 181 is specific to affordable housing. So the exemptions that are in tier 1A and tier 1B are for, you're exempt from Act 250, so.
Correct. The existing exemptions under Act 250 are for affordable housing, but yes, it's moving towards all housing.
Okay, well, that's interesting. There are existing exemptions. Would that be a difficult thing to address in 2 minutes?
No, so currently for the last 15-ish years, Act 250 has had a concept called priority housing projects. That means if it is an affordable housing project located in one of the designated areas, downtowns, Newtown Center, designated growth area, they can be exempt if the project is at least 20% of the units are affordable for at least 15 years. So that exemption has been existing. In Act 181, additional housing exemptions were added. Sorry, let me get to the page. It's in Z. There's additional exemptions for housing. Currently for the next 2 years, new town centers, growth centers, neighborhood development areas, 75 units or fewer, In village centers, the zoning and infrastructure and a quarter mile around those areas, 50 units of housing are exempt from Act 250. And then in all housing is exempt in downtowns with permanent zoning and infrastructure. So again, those are not specific to affordable housing. There is also a prior exemption from 2 years ago that for the priority housing projects, there used to be a cap on the number of units that could fall into that exempt category. That cap has been removed also.
Representative Lipsky.
Ellen, when that exemption's 20% affordable, 15. Does it distinguish whether it's for rent housing or for sale housing?
Yes, there are actually details on both of those things. So yes, it can be either. And there's a calculation for what is affordable for either owner or rental. Yep.
Farm worker housing on the farm, or what about off? Is it by use?
What about it?
I wondered if it's exempt.
We don't have a distinction in statute specific to that. So if it falls into one of the many exemptions in section 31 of Act 181, it might be exempt. But there isn't anything specific about farm worker housing.
Okay. Anything else? And then just back to one of your very first points. If you are in a town with zoning and subdivision laws, anything under 10 acres, Act 250 doesn't apply.
Correct. Unless because there's some other things like you can't drill an oil well regardless of the acreage. Like so there's some other little technical things.
if you wanted to build a home.
Right. If you wanted to build a home, probably not.
Okay. And then in a town that didn't have zoning, on a lot that was 1 acre or less, you could build a home without triggering Act 250.
Okay.
All right. We will not.
Oh, and single individual homes almost never trigger Act 250 because they're not for a commercial purpose. They're for a residential purpose.
Individual homes.
Yes.
Okay. As soon as you have a duplex, does that change or?
Unless it's built, if it's built by the owner, it really is about if a commercial is largely if it's being built by someone to be sold. And so like, owner constructed projects, or like the developers who build off one or two at a time may not trigger Act 250. And that's because there's that definition for housing. It's 10 or more units. So there are a lot of developers that construct 9-unit houses without triggering Act 250 or apartments without triggering Act 250.
And that could be on a large lot.
Yes.
Anywhere.
Yes.
Yeah. Large or small.
Within a certain distance, within a certain amount of time.
That's correct. All of these things are additional details. Yes.
So many details. All right.
I've got a lot of buildings.
Yeah. Well, it's been very, very helpful, Ellen. Thank you for joining us this morning.
You're welcome. Thanks.
And I was gonna say, we know where to find you, but maybe we don't know where to find you. Since you're next door now, right?
Yes, I am across the parking lot at 2 Aiken. I'm on the second floor, as is Mike. You're welcome to come see me. But otherwise, I'm also always happy to answer questions.
Thank you.